Everything else on this exhibit, which we just received, is beyond the scope of the court's order. We've not been provided notice of it. It wasn't in his original preliminary report. It is being sprung on us in the middle of trial. The court has ordered on this. We had a hearing on this. The court gave the defense opportunity to put us on notice of these things. We talked about these limitations. There was an agreement among the parties as to these limitations, which led to your order, Your Honor.
Yeah, I'm a little bit challenged when you say, is there something that I'm saying that draws the face that you're making? Go ahead, say what you want to say.
I have to say, Your Honor, yesterday I was the target of your ire for disregarding your orders. Today, the defense is disregarding your order.
I'm not criticizing you for bringing up this issue. I think it's legitimate. But it's not something that sways my judgment in the case. And unless you can tell me that you have reason to believe that that doctor is going to testify differently about some of these other time periods within that less than 5 minute period, then I'm going to allow the testimony to be given.
If I may respond, Your Honor.
Please.
Yesterday, as I said, I was under the court's ire.
You know, I don't want to talk about.
Well,
why don't we
I think it's a fundamental fairness issue, Your Honor.
All right, say what you want to say.
If I'm being held to obey the court's orders, I'm asking that the defense be held to that too. This is something we litigated at a Daubert hearing. We spent time on this.
You know, I am going to interrupt you, and then I'm going to let you talk again. But I was talking yesterday about the Constitution of the United States and how the Supreme Court has interpreted it for 50 years. That's not what we're talking about here today.
So, this is a notice issue to the state. We have not been provided proper notice of this, and clearly if the shoe were on the other foot and we tried something like this, there would be quite a kerfluffle about that.
I'm going to try to let you do it in a prudent way, and if there's an objection, I'll deal with it.
Okay. Can I list the ones that I want to raise for so we're
No, because you can object when it happens. Because maybe, see, if I rule on everything now, then I may be talking about things that may never become an issue, and I'd rather, the jury's in the library now, and I'd rather get them out here.
Okay. First of all, Your Honor, this was the subject of a motion. I'm well aware of that, and the court left the door open.
For me, not for you.
My understanding of
you should have come and asked for reconsideration. You did on the one motion, and in fact, I granted your motion for reconsideration.
That was not our motion.
Excuse me. I did. I granted.
We did not move to reconsider.
That was their motion.
We have not filed any motions to reconsider in this case.
That was their motion for reconsideration, which I denied. But I said I denied it, or I indicated a bias towards denial is what I did. Held it open with a bias towards denial. Why would you think that that made it okay for you, without any advance notice, to bring this matter before the jury? I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that. And it gives, I'll leave it at that. So I don't know what you're up to.
May I respond?
Yes.
We filed an other acts motion on this exact issue because, in my mind, and I argued this, it is identical to what was going on the night of August 25th. Your Honor, with all due respect...
I'm not going to rehash the motion. That's absolutely untrue. No. Your argument's of record. My comments are of record, and why I ruled as I did is of record. There's nothing that I heard in this trial to suggest anything's changed. Even if you're correct in your assumption that you know more than I did at the time, you should have come to the court and say, I want to go into this. Why you would think that you could go into it without any advance notice to the court, I don't understand that. And as the defense is pointing out, you're an experienced trial lawyer, and this should not have been gone into.
He has mentioned that he's acknowledged that he's used this gun to protect property. He's also just acknowledged that he knows he can't do that. I am attempting to impeach him now.
You know, there's a lot of difference between commenting about something when you haven't got a gun and threatening someone when you do.
You know, it's interesting, Your Honor, because the entire defense theory in this case is Joseph Rosenbaum, who was unarmed.
I want you to tell me what the defense theory of the case is. May I
respond to what you just said, Your Honor? I'd like to respond to what you just said.
Slow down, please.
I am attempting, with the defendant, to use his mere verbal threat on August 10th, 15 days prior, that he's going to shoot shoplifters with his AR-15 to impeach the defendant in a murder trial. I would ask the court's forbearance to do that the door is open now to this testimony. And I continue to believe that his state of mind, his intent, his belief as to self-defense is the core of this case. That was the basis for my motion.
I'm going to interrupt you now because you're talking about his beliefs. I think that's what they call...
His statements to, Your Honor. Because he just said, can't use deadly force, can't threaten to use deadly force to protect property. So now I'm impeaching him on that.
Just hours ago, I said I had heard nothing in this trial to change any of my rulings. So why...
Testimony, Your Honor.
Pardon me?
That was before the defense testimony.
Don't get brazen with me. You knew very well. You know very well that an attorney can't go into these types of areas when the judge has already ruled without asking outside the presence of the jury to do so. So don't give me that. Whether premeditated murder or whether self-defense, that's for the jury to decide. But I don't see the similarity. I said it couldn't come in, and it isn't coming in. No matter what you think.